disconnected, they can recall. Today we'll be talking about divorce-proofing your assets. The overview of today's presentation, we're going to be speaking of pre-marriage agreements, postnuptial agreements, cohabitation agreements, protecting assets in divorce when you use an international trust, joint control of marital assets, safeguarding community and separate property, and the use of the transmutation agreement for that. Asset protection, that's the overall thing that we do here, and what we like to do is break down our webinars into much smaller topics and tell you how the asset protection really works with it. So again, today we're going to talk about how it works with divorce. The asset protection is a legal way to protect your assets from future potential creditors. A creditor can be anyone who says they owe you money. Whether they truly are owed money or not, they can still be considered a creditor until that's been decided. So the goal here is to own nothing and control everything. And if you already have an asset protection plan, then maybe it's enough, but what you want to do is you always want to review it if there's a change in circumstances in your business or in your family, just to make sure, same with an estate plan, you want to make sure that it's up to date. Sometimes they have to be updated, the plans, and sometimes you can actually even downgrade them if necessary. Your wealth is in danger. Why? Because there's over 100 million lawsuits that are filed each year, and that number keeps growing. And depending on where you live, it can be a much greater percentage. For instance, in Florida, we're very litigious in Florida, so lawsuits, it can be for any number. You see people come in here all the time with complaints against them for things you would actually not believe. So really there's essentially a 1 in 4 chance you're going to be sued within the next year. Now whether that is personal or business, obviously that'll depend on you, and you'll probably have an average of 5 lawsuits over your lifetime. Now you may not be one of those people who has 5 lawsuits. You may be a person who has none. You may be a person who has 10. That's just an average. And then, the 50% plus or minus chance of divorce, we're going to get into that a little bit more because obviously that's going to be the subject of today's webinar. Liability insurance, highly recommend it. There's no reason not to have it. It's really a cheap way of sleeping at night for the most part. There's an example we like to tell you about for a client who was on a vacation with his family in one of the islands to take out a jet ski. And when he took out a jet ski, he ended up running over a snorkeler. The snorkeler actually had severe injuries, and the client actually had an umbrella policy. He'd been paying on it for about 15 years, and he had a $5 million umbrella policy. And the snorkeler wanted $1 million. So the client said, no problem. The umbrella policy is going to cover it. Told the insurance company, pay it. The insurance company said, no, we'll offer $100,000. They went back and forth. It eventually was at a stalemate with the snorkeler wanting about $700,000, and it went to court. In the end, the snorkeler won a multi-million-dollar judgment, and the client had to deal with the insurance company for years and years and years until the insurance company ended up settling the claim, and the client had to get reimbursed from the insurance company because the insurance company had acted in bad faith. But that was many years of his life that was taken up, and it's time value of money. So even though insurance is great, you've got to be really careful because the insurance might either be inadequate or the insurance just may not be enough, or it may not cover the risks. In that guy's case, it actually did cover it, but he had to go fight with them, fight his own insurance company to get paid. Your coverage may be inadequate. I've had clients who've come in who've had car accidents and not realized that they were just rolling over their payments every year and just automatically paying for renewing their insurance, not even realizing that the coverage that they had was, $10,000 of coverage. They just kept paying, didn't even think about it, didn't have it reviewed, and then they have a car accident, and now they're going to have to pay out of pocket because they didn't have, 100, 300 coverage that they probably would have had if they'd actually thought about it. Obviously, the first thing they did was up their insurance, but at that point it was kind of, too late to cover the accident that they already had. So your insurance may be inadequate, so that's obviously pretty critical that you have that reviewed. But in terms of the inadequacy, it also could be that you don't have the proper types of insurance. So, no problem getting the insurance, highly recommend it, but make sure you review those policies. Your insurance company could go bankrupt. That's not something we would have talked about 15 years ago. But then we saw things like AIG, where they had to be bailed out. Even the large insurance companies can go under. And if they go under and they're not bailed out, then any policy that you have is not going to be paid. In addition, you've got things that may not be covered. Today we're talking about divorce. I think there's probably 1 or 2 policies out there now that cover the risk of divorce, but most people don't have that. And considering, the rate of divorce, probably more insurance companies to cover it. There's also other types of financial risks that insurance companies don't cover. Probably a subject of another webinar. I don't know if we've done it already on captive insurance companies. That's something that large companies can do in order to insure against the smaller risks. It's not something we're going to be talking about today, but it is something that can be used to insure against, the things that most large insurance companies would not cover. Here's how asset protection works. We've already said what it is, but the main thing you want to do is you got to protect yourself before you have the problem. If you don't come in before you have a problem and set everything up, then it's possible we can't help you. And even if we can help you, your options have just been severely limited. So the key is to be proactive. Get yourself protected before. Come in when you're young. Come in when you're just starting out. You start with a basic plan, and then you add. You don't have to start with, a full international plan or a very complex plan. But if you've got the basic plan, you can build around it. And, as long as you've started everything before you have an issue, then you've got a really good amount of protection. The other thing you want to do is never assume that everybody's going to have the same type of plan, because it doesn't work for everyone. Your assets are going to determine what type of plan you have. So there's no one right plan for everybody. Doesn't mean you can't have certain elements that are consistent, but each plan is going to be tailor-made for your particular assets and can be changed based on future assets and how they add into whatever your current plan is. The things we like to warn you about when it comes to asset protection are things that people don't realize. Number one, you're never going to hide your assets in a good asset protection plan. What you're going to do is, sure, you want to maximize the privacy, but assume that the IRS is going to know everything you're doing. Your CPA will probably know everything you're doing if you're filing your taxes correctly. Whoever else you choose to share that with, that's, your own issue. But don't think of it as hiding. Think of it as setting things up in a proper legal and ethical way where you can control your assets without having a creditor be able to take them from you. One mistake that people make is to title assets in the name of a straw. And what the straw means is usually that's someone else, whether it's a friend or a family member, who what you do is you don't want somebody to know you own something, so you have someone else be the record owner. Believe it or not, I see it a lot, and people don't understand. And when we talk about titling things to the spouse, it's similar issues. But if you title something to a third party, well, what happens if the third party gets sued? Well, that's considered their asset because they're on the books of owning it, and that asset can be lost to you. Number two, what happens if they get a divorce and their spouse takes the asset? Or what happens if you have a falling out and they just say, well, it's my asset, it's not your asset, and now it's gone, go prove it. So you really want to stay away from titling assets to straws. The same can be said for titling assets to your spouse. Every one of those arguments can be made, and obviously we'll spend a little bit more time on that one. Now I have some statistics here. The American Psychological Association says that 40 to 50% of U.S. marriages end in divorce. And that's pretty, I personally think that's may even be a little bit older on those statistics because I think it's even higher. And the percentage actually goes up if it's a subsequent marriage, meaning if you've been married before and now it's a second or a third marriage, it's more likely to end in divorce. We're going to talk a lot more about divorce, but keep those statistics in mind that probably about half of the marriages in the United States end in divorce at some point. The other thing you want to definitely avoid doing is fraudulent transfers. Keeping in mind that a fraudulent transfer is actually, it's a civil issue, not a criminal issue with what we're talking about. And that means when you transfer assets out of the reach of creditors who have either a judgment or some sort of potential claim against you. So that means if you incurred a liability, meaning you took out a mortgage, even though you were perfectly solvent when you took out the mortgage, if you transfer assets out of your name to avoid paying that mortgage, that could be considered a fraudulent transfer, and a creditor can come back and try to get a transaction turned around and say it was a fraudulent transfer. So you always want to be aware of what the fraudulent transfer statute is in your state to know what may or may not be considered a fraudulent transfer. And there are some varied rules with regard to that, but you should always get the advice of counsel on that one. And lastly, nothing you do should break any sort of laws. So if you're doing asset protection, just make sure you're working with somebody who's going to handle everything legally and ethically, which goes back to you're not hiding anything. Maximize the privacy laws wherever you're going to do things, but don't assume you're hiding anything. First thing I'm going to talk about today is strategies that you can use to proactively plan for a future divorce. Understanding that the family court, which is where most divorces take place, I like to consider like the Wild West. And the reason I say that is because you just never know what's going to happen there. Charged venue, where all the gloves come off, people get nasty and vindictive, even though most cases ending up settling. It could take years. It can cost millions of dollars in attorney's fees and forensic accounting costs. And, the physical and mental damage to all the people involved, the people that are getting divorced, the family members, and most importantly, the children, is usually fairly irrevocable. So you just want to, keep that in mind when we're talking today. So let's start with something that you can do to try to prevent at least part of that nightmare. First thing we'd like to talk about is a prenuptial agreement. Most people know what a prenuptial agreement is. It's an agreement between two people who are planning to get married. So on a contractual basis, the consideration there is the fact that they're actually going to get married. You usually want to address that at least several months before the actual wedding date. You don't ever want to leave that down to the wire. I have seen them where people are literally signing them, the morning of the wedding. It's a lot of pressure on everyone, and I think it kind of taints the festivities. So you really want to try to bang that out, several months before. And the reason I say that is because there is usually negotiating that has to go on for that. If you're going to do a bona fide prenuptial agreement that is going to hold up in court, it has to have been negotiated. There has to be some give and take on both sides. There have to be attorneys involved on both sides. Each one has to have separate counsel. If you don't have separate counsel, then it's potentially going to be put aside. In fact, in Florida, the attorneys for both parties have to sign off on the agreement. So there's really the only way around the separate counsel is to waive it. But if you do that, you're opening yourself up to that agreement never being upheld. And the things you negotiate in there are things like alimony, who's going to stay home with the children, compensation for, things of that nature, for who's going to pay for things. You can always put that in there. But mostly what you're dealing with is waivers of alimony, waiving of homestead in states like Florida where we have homestead, waiving of requirements to be put in an estate plan. Keeping in mind, none of this prohibits you from including your future spouse in your estate plan. But what it does is in the event of a divorce, it outlines, the rights of the parties in terms of property and money. I can tell you that the last time I did a prenuptial, there were 8 types of alimony that were mentioned inside the document. So we all think of alimony. Well, let me tell you, there's rehabilitative alimony. There's, I don't even remember the names offhand, but basically there's about 8 types that I used in this particular prenup. And that doesn't even cover things like maintenance and spousal support. So a good agreement is going to, cover everything under the sun to make sure the proper waivers are done, because it is a contract, and when there's a contract, that means everybody who decides they don't want to abide by the contract is going to try to turn over every single word in the document. What you also need to keep in mind is prenuptials cannot determine custody of children or child support. That will be up to whatever the resident court is if you get divorced. So you can put anything you want in there, but ultimately it's not going to be governing the divorce and the child custody arrangement. The court is going to make sure they handle that, as well as whatever the child custody guidelines are in your state. From an asset protection standpoint, the prenuptial is extremely useful because it allows each spouse to prepare an individual asset protection plan to protect from creditors and not just from the divorcing spouse. Because keep in mind, if you're keeping things together and you have a joint plan, which I believe we talk about a little bit later on, you're not going to have an asset protection plan when you get divorced, because now your joint plan is going to be disbanded. The postnuptial agreement is actually almost the same as a prenuptial agreement. The only difference is it's done after the fact, meaning it's done after marriage. Not a bad plan, but you don't rely on this, because what happens if your spouse doesn't agree to do it? So now you're married, you've made note beforehand, you've got nothing in writing, even though the spouse may have said, oh yeah, we'll do it later. Well, guess what? What if they then say, nah, you know what, I don't want to? So you can have an issue there where, they can then say you coerced them. And if you coerce somebody, then the contract's not going to be upheld. So you have to be extremely careful if you're going to take that leap of faith, get married without the prenuptial, and rely upon a postnuptial. The other thing is, if you do the postnuptial, well, maybe you've already commingled assets together. Maybe you've already combined assets. So now you have to separate things out, and you all have to agree to it. That's not really the best way to handle the situation. I've seen postnuptial agreements used for several reasons. Number one, I've seen it where early in the marriage they seem to be having problems, and one of them wants to end the marriage because they don't want to get too entrenched in marital property, and the other spouse wants to try to keep it going. So what I've seen them do is actually do a postnuptial at that point, kind of as a good faith agreement that they'll try, but if it doesn't work, then they've already determined the property and they don't have to get into a big battle over it. I've also seen it where families have come in and insisted upon either a pre or postnuptial agreement because there's a family business involved, and they don't want a divorcing spouse to be able to take part in the in-laws business or own any part of the in-laws business. So these are all reasons you might do a pre or postnuptial agreement. But again, if you do the postnup, you are actually relying upon your spouse to be agreeable that they're going to do it and not to claim coercion. So it's either going to be fair or it's going to be fought. And you also want to, of course, make sure that neither one of them has defrauded each other. And the same rules apply whether it's a pre or postnuptial. You need independent legal counsel. What that usually means is one party will have their attorney draft the agreement, and the other party's attorney will review it and find things that they want changed, and they negotiate back and forth. One thing I wanted to mention in here is tenants by the entireties. And the way tenants by the entireties works is it's actually a type of ownership that you can have. So I'm sure most people have heard of like joint with rights of survivorship. That's one type of ownership you can have, and that could be among any 2 or more people, because they can own property together, whether it's real estate or bank accounts or any other type of property, where 2 or more people own it, and then as each one dies off, the other one survives to the property. The last one who remains is obviously the sole owner and then can pass it on to whomever they want to pass it on to. There's zero asset protection in joint tenants with rights of survivorship. The way that works is if any one of those owners has a creditor, the creditor can take the entire property. Differ that with tenants by the entireties. Only married couples can use tenants by the entireties. It's the same concept of survivorship. So if either one of them dies, the other one survives to the whole property. However, the way it works is that a creditor of one spouse cannot reach the property of tenants by the entireties. So for instance, if husband has an account with $50,000 in his own name, wife has an account with $50,000 in her name, and husband gets a judgment against him, the creditor can't take the wife's account, but they can take the husband's account, and vice versa. However, if they put the account together and put $100,000 in an account and it's tenants by the entireties, then the husband's creditor can't touch anything and the wife's creditor can't touch anything. The only way they can get at it is if they have a creditor of both of them. So if it's a joint debt and the creditor gets a judgment against both of them, then all bets are off and they can actually go after tenants by the entireties property. Tenants by the entireties, or TBE as we like to call it, is not available in every state. It's probably in about half the states. Some states only have it for real estate. Some states have it for real estate or personal property. Florida is one of those states that has it for anything. You could own a pen as tenants by the entireties. You can own a bank account. You can own a brokerage account. You can own real estate. So you need to know what your state laws are to know if you can actually take part in tenants by the entireties. But then we get to the divorce factor. So when there's a divorce, the minute you're divorced, there's no more tenants by the entireties, which means not only does it sever the survivorship aspect of it, but it makes each party a 50% owner in the property, which means husband owns 50, wife owns 50. If one of them should die before they get rid of that property, then 50% goes to their heirs, and the other 50% is still held by the other spouse, the divorced spouse. So it's very important to understand that while tenants by the entireties actually has some asset protection, it does not really help you in the event of a divorce, and it's not really the be-all, end-all which you should rely upon for asset protection. We do a lot of international trusts here, and international trusts are actually generally misunderstood, but what they're for, again, it's not about hiding those assets, it's about protecting the assets of future potential creditors. And the way this works is you set up a trust, and the person that sets it up is the grantor or the settlor, and they actually set it up for their own benefit. It's called a self-settled spendthrift trust. So you self-settle, which means you create it for your own benefit. You are not the trustee. The trustee is out of the U.S. jurisdiction. It's usually an international trustee. And that trustee manages your assets that are in the trust for your benefit. But the trustee has complete control, which means that if you want to get something from the trust, you want to get a distribution, you have to request it of the trustee. The trustee can say yes, and the trustee can say no. They're under no obligation to release those funds to you. Because they're under no obligation, that means that those assets are protected from creditors. Creditor could be your spouse. So if you set this trust up, hopefully long before you contemplate divorce, and hopefully you've set it up with assets that are your sole assets, your separate property, then there should be complete protection. I mean, nothing's ever 100%, but there should be protection on an international level because you just can't access that money. If you can't access it, neither can your spouse. Now, there have been court cases where there have been issues with these in terms of, the judge saying to somebody, to the spouse that has the trust, order the trustee to give you the money. And the spouse says, well, Your Honor, I don't have control over that. I can ask, but if they don't want to do it, they're not going to. If you cooperate fully and even write the letter that, say, judge, dictate that letter to me, tell me what you want me to tell the trustee, and you do exactly what the judge says, then generally you're going to manage to skate out of using those assets as part of the divorce. Again, it's the Wild West. It doesn't mean that, a judge can't say, I'm pissed off and I'm going to send you, into jail for a little bit for contempt. But ultimately, most of those people, if they've got the Constitution for it, they manage to safeguard that money. With that in mind, that doesn't mean that your assets that are residing domestically aren't going to be used to compensate for the money that's being held internationally. So your spouse that's suing you for divorce and trying to get at your international money may end up getting a little bit more domestically, but in the end, you've protected your international assets through the trust from your spouse as well as any other creditor. So it does work. But again, you have to, plan proactively because it's not always possible for you to open up an international trust at the late date. Let's talk about husbands and wives work together and put their money together and commingle their assets. What's the problem here? So it's not uncommon, two people go into a marriage hopefully with really good intentions, and they very often commingle their money. That means that they put the money together, they buy property together, and then it's a question of, okay, who's going to control it? So, you have to be very careful if you're going to, commingle your money, that both of you actually have control. The problem is sometimes what people do, and we talked about this earlier on, if you title property just in the one name, but you title the property in the spouse's name, the spouse that has, much less vulnerability. For instance, it's his mom. It's not the husband's a doctor, the wife stays at home. Her main vulnerability is driving a car, whereas he's a doctor and, serious vulnerability, but maybe he puts the property in the name of the spouse, in the name of his wife. If you do that, obviously you run the risk that the spouse can run off with the money, spouse can get sued, the spouse can, sell it if they're feeling in the mood, and you really can't control it. So if you're going to do that, what you want to consider doing is maybe having some sort of durable power of attorney where you can actually still exert some control over the assets even though they're in your spouse's name. But I always say if you put things in the wife's name and then there's a divorce, well, the wife is, much closer to getting the asset because they already own it. They can control it during the whole divorce process. And the one who controls the money is the one who's generally going to win in the divorce. So you want to really think about that before you start, putting things in the name of the spouse. I think it might actually be a good idea at this point to talk about strategic divorce, because that's something that people have done, and I've definitely seen it done. That's where it's actually not a very volatile situation where the people kind of get along, but they've decided that, they don't want to be married anymore. Where one spouse actually has creditors and the other spouse doesn't, what you can do is you can use the divorce process to negotiate out a settlement where the spouse without the creditors gets the majority of the property. And then that makes the spouse with the debts very poor and can't pay their creditors. But it's a negotiated out settlement, and most of the time it'll actually hold up. You can even have the spouse that gets, without the creditors who gets more money, pay alimony to the other spouse so they can get an income from that. So there's a lot of things you can do if everybody gets along. The reason you would want to do that is because then what you're doing is you're safeguarding that money for the kids. So if you have kids and you give, let's say it's the husband who has the debt, the wife doesn't, you put the majority of the assets from the, in the marital settlement agreement to the wife, and therefore you're protecting that money for your children. So it's actually somewhat of a form of asset protection. Spouses should jointly assets assets. Well, we talked a little bit about that. Tenants by the entireties we talked about. General partners in a family limited partnership is a little different. We might use a family limited partnership as part of an asset protection strategy. Limited partnerships are great because limited partnerships have limited liability and control to the limited partners, and only the general partner controls. So what we would do in that situation is if both spouses are involved and you have both spouses as general partners, and therefore they control the bulk of the assets. Understanding that if there's a divorce, you're not usually going to have those spouses succeed to be general partners together because it's an unlikely practical scenario. So that has to be contemplated as part of the divorce. And where that becomes problematic is if you've got a good asset protection plan in place and you have this limited partnership, who's going to get the limited partnership? Is it going to be the husband, or is it going to be the wife? Who's going to remain the general partner? Are they going to split the limited partnership interest? It has to be contemplated as part of the divorce, especially if you were using it in high net worth families in order to shift estate taxes, get discounts, and that's a whole other webinar. But if you were using it as a gifting strategy, you want to make sure that it is fully contemplated as part of the divorce so that there's no tax consequences and you can still get some asset protection. Now, I've seen where even after a divorce, the husband and wife have still maintained interest in the limited partnership. Again, it's going to come down to whether or not they trust each other to be in control of the assets, because a limited partner can't demand any sort of distribution from the limited partnership. Obviously the working relationship is going to fare much better than the contentious relationship. And if you've got a good asset protection plan in place, then it's always better to, keep things friendly so that you can both benefit from the asset protection. If you've done asset protection together with your spouse, you want to make sure that when you emerge from that divorce that you both still have asset protection. Not just from each other and for future requests for modification under the divorce, but what about, the people who weren't, the creditors who were existing before? What about, even the attorneys who racked up astronomical bills, or the forensic accountants, who may have racked, I've seen cases where somebody just called the other day and said they had just spent, $1 million over the last few years on their divorce, including a couple $100,000 to the forensic accountant. People don't understand that those debts still exist even after the divorce is finalized and you've been wiped clean. So these are things that people, you need to contemplate every one of these things when you are dealing with the divorce. Let's talk a little bit about community and separate property. So there are 9 states which have community property. And community property is where a husband and wife in a community property state own property, and it's really just considered half his and half hers. If property is community property and you move to another state, it's still considered community property. So you have to be really careful. We'll talk about transmutation agreements in a few minutes, but you have to be really careful to know which property is what, because from both an asset protection standpoint, you have to know what you can actually protect. And from a gift and inheritance standpoint, you have to know what you can actually pass on to the next generation, because maybe you didn't own the whole asset. We've listed the states that are community property. We don't have to go into each one. Separate property is property that you come into the marriage with, or property that you receive as a gift or inheritance. So if I'm married and I'm living in the state of California and I get a bequest from my grandmother's will of $100,000, as long as I don't put that in my joint account with my spouse, that's still my money. If I get divorced, that's still my money, and no one can take that away from me, well, at least not your spouse. If, however, I take that $100,000 and I put it in a joint account, well, then guess what? I've just commingled that, and it's no longer separate property. So if you're going to maintain separate property, which is common if you have a prenup, a postnup, or if you're in a community property state, you never ever want to commingle. That means I wouldn't put the spouse on the account for convenience. I would have the spouse have absolutely nothing to do and no rights over that money. I might even go so far as to say that in a durable power of attorney, I would consider separating out that property. And if I'm giving my spouse durable power of attorney, not giving them the rights over that particular separate property, just to safeguard it and make sure it's never in contention that it was meant to be marital property. When you get divorced, your separate property is still separate property, which means your spouse cannot share in it. If you've done an exchange, so you had $100,000 that was in your personal account, you took the $100,000 and you bought a piece of property with it, it's still separate property. If you sell that property and you get the proceeds, it's still separate property. Again, if you then decide to put your spouse on the title for, simple reason of survivorship to avoid probate, you've just commingled the asset unless you have a postnuptial agreement that says otherwise. So think before you act. Certainly, seek counsel on these matters before you go and do them, because once you compromise it, it's now considered community property or joint property and becomes marital property. So you need to be really, really careful, whether it's a community property state or any other state where it's separate property, keep it separate. Otherwise, you haven't protected it from a divorce. Last, we want to talk about transmutation agreements. I don't see them very often in Florida because obviously we're not a community property state, but what this is if you have either separate property or community property when you're contemplating a divorce, and I believe that's the only time you can use one of these agreements, you would have an actual agreement that says we want to convert community property into separate property, or we want to convert separate property into community property, and that way the assets are handled in their proper characterization. Again, you must be contemplating divorce in order to do this, and you can't use it to fend off existing creditors. So people will use it when there are when they're contemplating that there might be future creditors, if they're contemplating divorce. But if you have an existing creditor, the transmutation agreement is not going to help you to fend off those creditors. If you're not married, then but you have a long-term relationship and you're living together, then they have something similar called a cohabitation agreement. Very often we see couples that have decided, for whatever reason, that they're never going to get married. And what they do is they have an agreement. It's kind of like a prenuptial agreement. And what they do is they have agreements regarding sharing expenses. If sometimes they co-own property, what are their financial responsibilities to each other and to the household. Now, there's no asset protection. You shouldn't have an asset protection plan as a joint plan, because if you do and you break up, then you're in potentially even a worse shape than if it was a divorce, because there aren't any real rights that either one of you has. So you have to be really careful. I've seen some very solid couples where they have combined asset protection plans. And from an asset protection standpoint, it's actually good because now they've got unrelated parties involved. On the other hand, when they break up, it does become extremely messy and it becomes a complete contractual dispute. So I'd be really careful about that. But there is a potential where you can have a cohab agreement when you are living together, sharing expenses. And all I'm going to say about it is it's very similar to a pre or postnuptial agreement. In the event that you've shared assets and you break up, what's going to happen?